Swayam Prabha. Digital India. Educated India.
Rule 24C, Expedited Examination of Applications. The Patents Amendment Act 2016 introduced a new process of examination by which an applicant could get the examination of the application expedited. This is introduced in Rule 24C. In Rule 24B, we had the occasion to see how the examination process works, and we saw the various timelines that happens after a request for examination is made. And we also found that the reference made by the controller to the examiner is the only event which does not have a stipulated timeline. It is just mentioned in the rules, it shall be done as soon as possible, but there is no specified timeline as to how quickly this reference has to be made. Apart from that, every other process within the examination or soon after the request for examination is made is drawn out by way of a timeline. Expedited examination is a special privilege that is allocated to two categories of applicants, which allows the applicant to fast track the examination of the application. Now let us see what those two categories are. Rule 24C1 states that an applicant may file a request for expedited examination in Form 18A. Form 18A was again introduced by the Patents Amendment Rules 2016, along with the fee as specified in first schedule, only by electronic transmission duly authenticated within the period prescribed in Rule 24B on any of the following grounds, namely, now these are the two grounds on which you could make an expedited examination or a request for an expedited examination. Again, this is a request for an expedited examination, namely A, that India has been indicated as the competent international searching authority or elected as the international preliminary examining authority in the corresponding international application, or the applicant is a startup. Startup is defined in the rules. Startup has special status in the first schedule. First schedule is the schedule which describes the fees. Startups are entitled to fees at the same level as individuals. So this is a privilege that is given to startups. Startups will be treated on the same fee structure as individuals, that is natural persons. So natural persons and startups are now together grouped as one category for the purposes of levying fees. So you can make a request for an expedited examination under Rule 24C using Form 18A, provided you have chosen India as the competent international searching authority or elected the international preliminary examining authority in India for the corresponding international application. Now, category A presumes that you have filed an international application. Category A is not open to an applicant who has not filed an international application. So, expedited examination, a request for expedited examination as per category A can only be filed by an applicant in India who has filed a foreign international application, who has filed an international application and has chosen India as the international searching authority or the international preliminary examining authority. Now, India is International Searching Authority as well as an International Preliminary Examining Authority. This was introduced by the Patent Amendment Rules 2013. Now, by this they created Indian International Searching Authority, that is Rule 19A introduced the International Searching Authority in India, and Rule 19F created the Indian International Preliminary Examining Authority. So, these two authorities were created by the Patent Amendment Rules 2013. So, the first category pertains to cases where an applicant has filed an international application and has chosen India as the International Searching Authority or the International Preliminary Examining Authority. And these changes were introduced into the patent rules by the amendment in Patents Amendment Rules 2013. The 2013 amendments made the Indian International Searching Authority and the Indian International Preliminary Examining Authority came into being by that amendment. So, that is the first category. For you to make a request for an expedited examination, you need to file a international application. In the absence of filing an international application, category A will not be open to an applicant. So, it is mandatory to, while seeking before filing form 18A, that you have first filed an international application and have chosen India as either the ISA, the International Searching Authority, or the IPEA, International Preliminary Examining Authority. Form 18A can only be filed by an entity other than a natural person or a startup, provided there is an international application in place. So, the first category pertains to an applicant who has already made an international application in India and has chosen India as the ISA or the IPEA. The second category is quite simple. If the applicant is a startup, if the applicant is a startup as defined under the patent rules, then the applicant can make a request for an expedited examination. Now, the rules give the definition of a startup in Rule 2FB. A startup is defined in Rule 2FB. Now, let us look at the definition of a startup. Startup is defined in Rule 2FB, was introduced by the Patent Amendment Rules 2016, and this was a part of the Startup India policy that the Patent Office now has relaxed fees and expedited examination for startups. So, these are two privileges that are extended to startups. One, you have a relaxed fee structure. The fee structure for the startup is the same as it is for natural persons, and startups can also seek the privilege of an expedited examination. The rules define startup as startup means an entity where one, more than 5 years have not lapsed from the date of its incorporation or registration. So, it's not been in existence for more than 5 years. 2, the turnover for any of the financial years out of the aforementioned 5 years do not exceed rupees 25 crores. The turnover, there is a cap on the turnover in the 5 years of its existence, it should not exceed 25 crores. 3, it is working towards innovation, development, deployment or commercialization of new products, processes or services driven by technology or intellectual property. Now, this is the third requirement. The first requirement is a requirement with regard to its existence, the time period since it came into existence, that should not be more than 5 years. The second requirement pertains to its turnover. The turnover should not exceed 25 crores in the 5 years since its incorporation or registration. So, the first requirement was a requirement with regard to the term, for how long it has been in existence. The second requirement is with regard to its turnover, its financial position. The third requirement is with regard to what the startup does. So, the first requirement is the life of the startup, whether it is young or old, in the sense that if it is less than 5 years, it qualifies for the startup status. Second requirement is a financial requirement, to see that the turnover is not in excess of 25 crores over the years. The third requirement pertains to what the startup does, the work the startup is involved in. Now, the third requirement specifically states that it should be working towards innovation, development, deployment or commercialization of new products, processes or services driven by technology or intellectual property. So, a startup could be in the business of developing new products, new processes or new services. It has to be driven by technology or intellectual property. Now, the term intellectual property may broaden the idea of a startup. For instance, if there is a publishing company which develops copyright, it's a content providing company, it develops copyright in an innovative way, say it makes online courses and it delivers video lectures to its students. Now, this could technically be treated as a startup because it works towards innovation in the education sector and it produces new products, processes or services being education being delivered online, driven by intellectual property, because all the content that is delivered can be protected by copyright. So, this startup could technically qualify for a status under the definition, though it may not have anything to do directly with technology, because the option that is given in the definition is that you could be working on technology or you could be working on intellectual property. Yet another instance, if there is a design company which makes logos or trademarks for its customers using an online platform, again you could find that this could qualify for a startup status because it is dealing with intellectual property. Now, the question arises, what will these firms who are dealing with intellectual property in a different segment, say copyright or trademarks, will have to do with filing of patents? That's a larger issue that the startup itself will have to address. But if the startup is working on these lines, either on technology or on intellectual property, that's a qualification or that's a requirement that will be looked into by the patent office before allowing the startup the benefits under the act and the rules. Now, how does the patent office determine whether a startup is a startup? Now, for that there is a form that has to be submitted by a small entity or a startup. Now, if you claim the status of a startup, you have to file Form 28 to claim that status. Form 28 was again introduced in 2016. So, for startup, Form 28 has to be submitted to claim the status of a startup, because the first part of the definition says that it should not have been in existence for more than 5 years since its registration or incorporation. Now, incorporation we understand as a body corporate. Registration could be something else completely, because you could register MSME, a micro, small, medium enterprise under the MSME Act of 2006, MSME Development Act of 2006, and that registration will qualify you for the status of a small entity or micro or a medium entity. Now, you could register yourself as a partnership firm and still you could claim the benefit of a startup. you could incorporate yourself as a private limited company and still claim the benefit of a startup. You could incorporate yourself as a one person company, which is a new entity that has been created by the Companies Act. So, in 2013. So, you could do any of these things and claim the benefit of a startup. But the point is, to claim the benefit, you have to file Form 28 and you have to claim that startup status. Mere registration or incorporation under any of the acts or the legal system will not allow you to claim the status. You have to file Form 28 to claim the status. So, the three things: the fact that the term has to be young, the status should be in existence for less than 5 years, its financials should not be more than 25 crores, and it should be working towards innovation, development or deployment or commercialization of new products, services and processes driven by technology or intellectual property. Now, it should either be technology driven or IP, intellectual property driven. These are the three requirements. Now, these are the positive requirements. Now, the definition further goes to say what will not amount to a startup. They are mentioned in the proviso. Provided that any such entity formed by splitting up or reconstruction of a business already in existence shall not be considered as a startup. So, an existing business is shelled off into a smaller unit, it will not amount to a startup. So, you have to start something afresh to claim this status. Provided further, the mere act of developing a product, services or processes which do not have potential for commercialization, or undifferentiated product or services or processes, or product or services or processes with no or limited incremental value for customers or workflow would not be covered under this definition. Now, the third part of the definition, as we mentioned, was the function. What function does the startup do? It just explains that the startup should be doing something substantial. If it is not developing products which don't have a potential for commercialization, it will not be accorded the status of a startup. If it is coming out with undifferentiated product, services or processes, there is no innovation, the products are undifferentiated, again the benefit will not be granted. The products or services or processes with no or limited incremental value for customers or workflow. Now, if there is no value addition by the products, services and processes created by the startup for the customer, then again it will not be covered under this definition. Now, these are broadly worded phases. Now, you can assume that the decision on whether to grant the status of a startup will rest with the controller, because the form has to be submitted to the controller and the controller will have to take a call on that. Now, we have few explanations to the definition. So, first we saw what are the three positive requirements, then we saw two exceptions, what will not amount to a startup, and now we have 5 explanations. Explanation 1, an entity shall, so the explanation says when a startup shall cease to be a startup. Explanation 1 states that if there is a startup, when the startup will lose its status of a startup. Explanation 1, an entity shall cease to be a startup on completion of 5 years from the date of its incorporation of registration, or its turnover from any previous year exceeds rupees 25 crores. So, once it crosses the 5-year period, it ceases to be a startup and its income or its financials turnover exceeds 25 crores in any of those previous years, then it ceases to be a startup. Now, this is condition 1 and 2. So, if it crosses the threshold in 1 or in condition 2, it ceases to be a startup. Explanation 2, entity means a private limited company as defined in the Companies Act 2013, or a registered partnership firm registered under section 59 of the Partnership Act, or the or a limited liability partnership under the Limited Liability Partnership Act 2002. These are the three entities that could be considered for the startup status. So, the registration is required under, or incorporation is required under these three enactments for an entity to be regarded as a startup, which also tells us that if you are registered under the MSME Development Act, the Micro, Small and Medium Enterprises Development Act 2006, then you will be accorded the status of a small entity, because small entity has a different fee structure under the Patents Act. So, to be a startup, you need to be registered as an entity in one of these three enactments, either the Companies Act or the Partnership Act or the Limited Liability Partnership Act. Explanation 3 states that the term turnover shall have the same meaning as defined in the Companies Act. There is a definition for turnover, what the turnover means. So, the same definition will apply in this case as well. Explanation 4 states that an entity is considered to be working towards innovation, development, deployment or commercialization of new products, processes or services driven by technology or intellectual property. This is the third condition. If it aims to develop and commercialize a new product or service or process, or a significantly improved existing product, service or process that will create or add value to customers or workflow. Again, the improvement or the value addition needs to be significant. Now, we saw this in a different language in the second exception, which said that undifferentiated products, processes will not be considered for granting status of a startup. Then if it is not commercialized, then again it will not have status of a startup, and incremental value, limited incremental value or no value addition will again not be considered for status of a startup. Now, this is differently phrased. It just says that the entity should aim to develop and commercialize new products, services or processes, or significantly improve existing products. It is not a mere or an incremental improvement, it has to be a significant improvement. So, again these are with regard to what is significant. Again, because the entity will now have to file Form 28, it will be reasonable for us to expect that the controller will be taking a call on that. Explanation 5, the reference rate of foreign currency of the Reserve Bank of India shall prevail. Now, if there is a startup which is a foreign entity, or entity that has some operation in a foreign country, foreign entity still will have to be registered under one of these acts, because that is when it will be regarded as an entity. But if the turnover is in, say, in dollars, in US dollars, then the reference rate for foreign currency of the Reserve Bank of India will apply to see whether they have exceeded the 25 crore turnover mark. So, that is the definition of startup, an elaborate definition. It has got 3 positive components, 2 provisos and 5 explanations. Subrule 1. Subrule 1 gives the 2 categories of applicants who can claim the status of a startup. The first one, the applicant should have preferred an international application, and the applicant should have chosen India as the ISA or the IPEA. The second category is that the applicant needs to be a startup. So, we understand the first category. If in the first category the applicant is also a startup, then the applicant need not worry about taking an international application. Whereas, the first category applies to a non-startup, that is an entity which could be a small entity or it could be a corporate entity. These are the 3 categories. You could either be a natural person or a startup, that is one category for the purpose of fees. you could be a small entity or you could be a corporate entity, which is the other category, which is a category other than a natural person, startup or a small entity. So, if you fall within that category, if you are not a startup, then if you need to expedite an examination of an application, you must file an international application. Otherwise, there is no way an entity which is not a startup can get its application expedited, the examination of the application expedited, unless there is a corresponding international application filed. So, if there is no international application, entities which are not startups will not be able to take the expedited examination route. Now, route is now explained. How does the Patent Office proceed when a request is filed? Sub-rule 2 states that a request for examination filed under Rule 24B may be converted to a request for expedited examination under Sub-rule 1 of 24C by paying the relevant fees and submitting requisite documents as required under Sub-rule 1. Now, if you had taken a request for examination under Rule 24B, which is a normal request for examination, which you would do using Form 18, you can convert that into a request for expedited examination by paying the relevant fees. The relevant fees are mentioned in the first schedule. Now, this allows you to convert a request that you have already made, a normal request for examination, into an expedited request. Now, obviously, if you are claiming the status of a startup, then you will have to file certain documents to claim that privilege. So, if you look at Form 18A is the form that is taken along with the request for expedited examination. Now, in clause 2, you will find that there is this statement where the applicant makes the request for examination bearing dash for application for a patent number dash filed on, these numbers have to be filled by the applicant, may be converted to a request for expedited examination of the patent application under Rule 24C. So, by filing this form can also be used to convert an existing request. Now, this is mentioned in clause 2, and in clause 3 the applicant will have to show whether it is a startup or whether it has indicated India as the ISA or the IPEA. Now, this has to be filled. So, going back to Rule 24C, Sub-rule 2 tells the instances where you could convert an existing request for examination to a expedited request by paying the relevant fees, and that is done by Form 18A, because Form 18 is already filed in that case. Sub-rule 3 states that except where the application has already been published under subsection 2 of section 11A, or a request for publication under Rule 24A has already been filed, a request for expedited examination shall be accompanied by a request for publication under Rule 24A. Now, this simply means when you file Form 18A, if you have not already filed Form 9, you have to file it along with Form 9. Now, Form 9 is the request for publication. Now, the idea is, why would you make an expedited request for examination if your application itself is not published? Because if your application is not published, there is no way the Patent Office is going to examine your application. So, it becomes necessary for the applicant to take Form 9 if he has not already done it along with Form 18A. So, Sub-rule 3 says that when you are making a request under Form 18A, you have to accompany it with Form 9, which is a request for publication. Now, the two cases where you will not do that are, it's quite obvious. The two cases where you will not do that is the application is already published, there is no need to then take Form 9, or the Form 9 is already filed. So, those are the two obvious cases where you will not file a form 9 with a form 18. It's already done, it's already published, or the form is already filed. Subrule 4 states that where the request for expedited examination does not comply with the requirements of this rule, such a request shall be proceeded in accordance with the provisions contained in Rule 24B with an intimation to the applicant and shall be deemed to have been filed on the date on which the request for expedited examination was filed. Now, 24B, you will remember, is the request for a normal examination, or what we call a request for examination. Now, if you take or if you file form 18A and request an expedited examination, but the controller feels that you have not complied with the requirements of the rule. For instance, you are not a startup or you have not filed an international application, then it will be very hard for the controller to accord the status of an startup for your application. In such cases, the request shall proceed in accordance with Rule 24B. Rule 24B, we know, is the normal application and normal examination process, the examination of an application. Now, Rule 24B is normally initiated by filing form 18, but in this case, because the applicant chose to file form 18A instead of form 18, but without satisfying the conditions laid out in 24C, the application will proceed as a normal application. So, though you have taken a request for expedited examination, if you do not comply with the requirements in the rule, then it will proceed as a normal request for examination under 24B. Understand that 24B is for the normal, we do not say normal, it is the request for examination, the ordinary one. 24C is the expedited request. If your form 18A does not satisfy the requirements under the rule, then it will proceed as a normal examination. The date will remain the same, because the date of filing the form 18A. Now, this could be regarded as a case of form 18A being converted into form 18. The date will remain the same as of the date of filing. Now, once the request is filed and assume that the request is in order, the applicant is entitled for the status of a startup. The controller feels that the applicant is entitled to claim the status of a startup. Subrule 5 then states that the controller shall refer the request for expedited examination along with the application specification and other documents to the examiner. The process is same just as it was in 24B in respect of the application where the request for expedited examination has been received in the order of filing of such request. Again, this is the same. The controller shall refer it to the examiner, provided that a request for expedited examination under this rule filed by a startup shall not be questioned merely on the ground that the startup ceased to be a startup after having filed the application for patent due to the lapse of more than 5 years from the date of its incorporation or registration, or turnover subsequently crossed the financial threshold limit as defined. Assume that a startup makes an application in its fourth year of its incorporation, and its financials are well within the limit. It has not exceeded 25 crores. So, let us say a startup after 4 years of incorporation makes an application, and let us also assume that the startup has a turnover of around 20 crores. Now, once the application proceeds, a request for expedited examination is filed. In the next 1 year, by the time the application is taken up for examination, the startup has already crossed the 5-year threshold. It is now in its 6th year, or the turnover has gone beyond 25 crores. Now, that technically would make the startup lose its status. But if a request for examination is filed while it was a startup, that request will proceed as though the startup still enjoys its status. It merely states that if a request for expedited examination is made, what is relevant is the point at which the request is made. If a startup is entitled to the status of a startup at the point in which the request is made. Subsequent change in status by crossing the 5-year threshold or the 25 crore threshold will not affect the request that was made. It will still proceed as an expedited request. So, the request filed by a startup. So, what the controller would investigate or would look at is the date on which the request was made. The date on which the request was made, if the startup fell within the definition of a startup, that is all that matters. Subsequently, as the application gets examined, if the startup loses its status, that should not be a ground for questioning the status of the startup. Subrule 6 states that once the reference is made to the examiner, the period within which the examiner shall make the report under subsection 2 of 12 shall ordinarily be 1 month but not exceeding 2 months from the date of reference of the application to him by the controller. We saw that in rule 24B, it was 1 month not exceeding 3 months. So, in this case they have cut it down by another month. So, it is 1 month but not exceeding 2 months. So, the examiner has a maximum of 2 months to give the report, whereas in 24B he has 3 months. Subrule 7 states that the period within which the controller shall dispose of the report of the examiner shall be 1 month from the date of receipt of such report by the controller. This remains the same in 24B and 24C. Subrule 8 states that a first statement of objections along with any document, if required, shall be issued by the controller to the applicant or his authorized agent within 15 days from the date of disposal of the report of the examiner by the controller. Now, in 24B that was 1 month, that is now been reduced to 15 days. So, there is a difference here. The controller's report, that is the first statement of objections, which was earlier called the first examination report, shall be sent within 15 days from the date of disposal of the report of the examiner. In a normal examination, it is 1 month. Now, that has been cut down to 15 days. Subrule 9. Reply to the first statement of objections and subsequent reply, if any, in respect of an application where the request for expedited examination was filed, shall be processed in the order in which such reply for such application is received. This is similar to what we had seen in 24B. The process for the order in which the request shall be processed will be the order in which the office receives them. Subrule 10 states that the time for putting an application in order for grant under section 21 shall be 6 months from the date on which the first statement of objections is issued to the applicant. This is again, there is a similar provision that which says that it should be 6 months from the date on which the first statement of objections is issued to the applicant. This is the same in 24B. The 6-month period is the same. Subrule 11. The time for putting an application in order for grant under section 21 as prescribed in Subrule 10 may be further extended for a period of 3 months on the request for extension made in form 4 along with the prescribed fee made to the controller before the expiry of the period specified under Subrule 10. So, before the 6-month period expires, you can make a request for extension of time by filing form 4 and you will be granted a further period of 3 months. So, the 6 plus 3 formula that we saw in 24B also applies here. Subrule 12 is important. It is important for us to understand 24B itself because this throws light on a timeline which is not there in 24B. So, we will look at this and we will go back to 24B. Subrule 12 states that the controller shall dispose of the application within a period of 3 months from the date of receipt of last reply to the first statement of objection or within a period of 3 months from the last date to put the application in order for grant under section 21 of the Act, whichever is earlier, provided that this time limit shall not be applicable in the case of pre-grant opposition. Now, this statement is not there in 24B. Subrule 12 can be seen as the part which closes a loop. A loop, if it's an open-ended loop, then there is a possibility that you could say that time can be extended. But in an expedited examination, the controller shall dispose the application within a period of 3 months from the date of receipt of the last reply to the first statement of objection. Now, this statement is simply not there, that there can be a last reply to the first statement of objection is not there in 24B, and there is no timeline in 24B which mandates the controller to dispose the application within 3 months. So, that is where the subrule 12 becomes important for us in understanding the timeline in 24B. 24B, which is the case of a normal request for examination being filed, there is no mandate to dispose the application within 3 months from the receipt of the last reply, whereas in an expedited examination the controller has been given that mandate. Either it is 3 months from the date of receipt of the last reply, or within a period of 3 months from the last date to put the application in order for grant under section 21 of the Act. So within 3 months from the last date to put the application in order, the controller has to dispose the application. Again, this provision to completely dispose the application is not there in Rule 24B. It also factors the fact that if a pre-grant opposition is filed, then the controller cannot dispose the application till the pre-grant opposition is disposed of. So, this timeline will not apply, or you may not be able to get an expedited examination done if there is a pending pre-grant opposition. So you could say that one way an expedited examination can be frustrated is when a pre-grant opposition is filed, because then the timeline need not be an expedited timeline, because the controller will be bound to dispose the pre-grant opposition before the application is disposed. Subrule 13 states that notwithstanding anything contained in this rule, the controller may limit the number of requests for expedited examination to be received during the year by way of notice to be published in the official journal. Now, the controller can make a statement in the official journal that in any given year they will be receiving only X number of expedited applications. So, anything that goes beyond that, the controller can say will be treated as an ordinary request for examination. Now, this is again to check the workload of the patent office. So, the patent office should not be burdened with a more stringent timeline, and as you saw in subrule 12, the controller has to dispose the application within 3 months. So, if it is an expedited examination, to prevent the patent office from managing a workload which could happen if the number of expedited examinations are increased, there is a limit that the controller can put on the number of requests that could be made every year.